To start with, what are the most important things to remember about being a good witness at trial? There are 3 steps to doing well in your trial testimony. First, listen. Second, think. Then, answer. If you follow these 3 steps, you'll do fine. Let's cover these in more detail. First, listen carefully to the questions asked of you. This is an important job. Do not interrupt the questioner. Even if you think you know what the question will be, jumping to conclusions or assuming what the question will be can cause you to answer the wrong question, like this witness.
Did you tell Brian that?
I never told Brian what Angie said about his evaluation. Instead, I told Keith.
Well, actually, that's not what I was going to ask. But now that you brought it up, what did you tell Keith?
This witness has now opened a can of worms, which will require her to answer questions she would not otherwise have been asked. This could be a problem if she's not discussed this issue with her attorney. Don't feel pressured to rush your reply. A short pause before responding gives you time to listen. You will not be expected to have instant, immediate responses to all questions. You don't always have these in normal conversations. This next witness is a good example of how to testify. He is obviously listening before answering the question.
When did you consider the terms of the contract to be met and satisfied?
Back on April 7th, when the certificate of occupancy was issued.
Some answers may require longer pauses for thinking than others. For instance, if you're asked for your birth date, your pause is going to be short. If asked a more complex question, your pause may be longer. It is important not to overdo the pause. If you take frequent long pauses, especially when you should know the answers, such as your address, it may appear that you're being evasive or stalling for time. If an attorney makes an objection while you're on the witness stand, stop speaking. Wait for the judge to rule and continue answering only when instructed to do so. Never try to slip in an answer after an objection is made, like this witness does.
Objection.
She told me she never saw that red light.
Sustained. The court orders the reporter to strike the witness's response from the record. Counsel, will you please instruct your witness to stop talking when an objection has been raised and to wait for the court to rule?
As you can see, the judge can admonish or scold you. This could also result in a mistrial. So now let's review. Step 1 was to listen. Step 2 is to think. Think before answering a question. Never answer a question before thinking about it. Make sure you completely understand the question before replying. Never answer a question you don't understand. But what if you don't understand the question? If you're confused or uncertain about any part of the question, let the attorney know this. You can ask the attorney to restate the question or ask it differently.
Could you please rephrase the question for me?
I'm not certain I understand that question.
I'm not sure what you're asking me is another good alternative, but do not give instructions to the attorney. It may make you appear bossy or argumentative, which is not a good thing.
You need to rephrase that question.
You'll have to ask that question differently.
When thinking about the question, you may feel that some words need clarification. If you're not sure of a word's meaning as it's being used in a sentence, ask.
Were you involved in that meeting?
What do you mean by involved?
While this response is fine, this next reply is better as it explains the extent to which you were involved.
I was at the meeting, but I did not plan it, nor did I talk during it.
If you simply said, yes, I was involved in the meeting, the attorney may assume that you were active in setting up or leading the meeting and prepared to discuss this. If you answer no, but the attorney can show you were at the meeting, it could appear that you're not being truthful. Keep this point in mind if asked questions such as, did you review the contract, or were you familiar with the location? If an attorney asks you a long question and you are not sure you fully understand it, ask the attorney to please break the question down for you or rephrase it. Sometimes you'll be asked several questions at once. This may be confusing because you may not be able to answer with a simple yes or no.
Did you see the accident? And did you see who got hurt?
This would be a good example of when to ask the attorney to please rephrase the question. Or you could clarify this by saying,
I did not see the accident happen. I did see people injured after the accident.
This witness understood that he was being asked two questions, and he separated these in his answer. Some questions do not correctly reflect your prior statements, like in the following example.
You told us in your deposition that you saw Nurse Edwards give Lance the medication on Tuesday. Was this in the morning or in the afternoon?
If you say morning, you're agreeing that you saw the nurse give the medications when you may not have. A correct answer to this question might be,
As I stated in my deposition, Lance told me that Nurse Edwards gave the medications in the morning, but I didn't see it happen.
This witness thought before answering and avoided giving an incorrect or misleading reply. Treat every question as an important one. The attorneys will have a specific reason for asking every question. You may not immediately see the importance, but know it's there. Always remember that the opposing attorney and their trial team are not your friends, no matter how friendly they are to you. They may want you to feel relaxed and comfortable because this encourages people to answer questions without thinking carefully first. This is dangerous. Always remember that they're on the opposing side of your case. If you're taking any medicines or have any physical or emotional situations that could cause you to think less clearly during your trial testimony, be sure to let your attorney know this. Also, avoid anything like alcohol or substances that could affect your clear thinking, and try to get a good night's sleep before your testimony. You will want to be alert and refreshed. Step 1 was to listen. Step 2, think. Step 3 is answer. After you've listened carefully to the question and thought about the question and your response, then and only then do you answer the question. If you don't know the answer to a question, just say so. Many witnesses make the mistake of answering beyond the original question, as in the following example.
How many children do you have?
Well, I have Alan, and he's in first grade, and he's just wonderful. And then I have Gianni, and she's my little angel, and she's at Donaldson. And I have Nico at home with me. He's just a baby.
This is not answering just the question. The following response is a better one.
I have 3 children.
Answer only the question asked. Do not add their names, ages, or grade in school. If the attorney wants to know this, he or she will ask. Answering only the question you are asked is one of the most important things to remember about your trial testimony. You can get in trouble by answering more than just the question. In order to be honest, you must answer the questions as asked. Do not offer new information you have not shared with your attorney. Your attorney will not like being surprised at trial. So, if you think you may be asked for certain information you have not previously shared with your attorney, be sure and discuss these items with your attorney before your testimony. Otherwise, this situation could backfire, and your attorney will not have had a chance to prepare you for follow-up questions from the opposing attorney.
Does your husband have any other sources of income?
Actually, yes. He made about $10,000 last year playing pool.
Really? Did you report this on your income taxes?
Well, I don't remember. I don't think so. No.
So you lied on your taxes, but you expect the jury to believe you now.
This witness clearly lost credibility with some jurors who will now question her honesty. If she'd shared this information in advance with her attorney, she would have been better prepared. Some questions cannot be correctly answered by a simple yes or no. To do so might cause you to give wrong information
Do you still use illegal drugs?
This is a no-win question. If you say yes, you're admitting you did use drugs, even if this is not the case. If you say no, it indicates that you did use illegal drugs in the past, but no longer do. The right way to answer this question would be to turn the question into a sentence that reflects the truth.
I've never used illegal drugs.
There are times when a yes or no response will not be a complete answer. If this happens, ask if you can explain your answer.
I cannot answer that question with just a yes or a no. It would not be a complete answer. May I explain?
Even if the attorney does not allow you to explain, you will have politely pointed out that neither a yes or no answer is correct. If the information is important, your attorney will ask you to explain later in your testimony. Extreme answers, such as never or always, can backfire. If the opposing attorney can show any exception to this claim, your credibility could be damaged.
Have you ever consumed alcoholic beverages?
Never.
Well, what about in high school or college?
Well, I did drink some beer back then, but that was a long time ago.
Well, didn't you just tell us you never drink? You weren't being entirely truthful with us, were you?
This is a classic example how responding always or never can get you in trouble. We've now discussed the three main steps of good trial testimony: listen, think, and answer. We'll now consider additional information that is very important in order to present well at trial. We'll refer to these as the 10 C's. Candid, competent, concise, certain, courteous, confident, consistent, composed, clear, and conservative.